Okay, good afternoon, everyone. Yep, there everyone is. Okay, good afternoon. Um, my name is Dominic Cabrero. I'm the chair of the Administrative Law Section. And as noted on the invitation, before we get started with the CLE, we need to just take care of a bit of business first. So what we'd like to do is hold section elections. And the nominees for this year are the current incumbent officers. I didn't receive any nominations for section officers. But this is a little bit unorthodox because we're, it's in the time of COVID. So we're going to be doing this by Zoom. And what we're going to do is do a Zoom poll. So you'll see my name and Judge Woodard's name and Mr. Alan Lightcap's name on there as well. And so we'll just get started with that in just a second. And if you are a section member, if you could just please vote, and we will close the voting after about 5 minutes, maybe 5 to 10 minutes. And then we'll move on with the CLE. Okay, so Lane, yeah, if you could go ahead and put that that poll up. And this is anonymous. I can't see the results. So yeah, don't be shy. Ordinarily we would do this by paper ballot, but unfortunately we have to do it electronically.
Looks like we got a good attendance here. I see some names that I recognize, and thank you all for coming, and really appreciate you guys making this a something that you're doing on an afternoon on a Tuesday. I know how busy everybody is, and thank you for coming. We hope we can give some valuable feedback on not only OSAH rules, but also just common sense advice on how to conduct these virtual hearings that we're all doing now.
Alan, Dominic, can you still see me?
Yes.
Wonderful.
Now, one thing that is really cool about Zoom while we're kind of just talking is there's this chat function that you can send chats to just one person or to the entire group. And I'm going to be monitoring this chat throughout Dominic's and my presentation. And if there's anything that something that's could be clarified, or if there's a question that comes up that anybody wants to make, please just send it into the chat, and I will interrupt and kind of. I hope that this is going to be a helpful thing, and we want to answer questions, and we want to answer specific questions that you might have as things arise. And so please do utilize the chat. And frankly, it's a great tool for your hearing as well. I mean, it's something I'll talk about when it comes to be my time, but please do use it.
Yeah, and thank you for doing that, Alan. And anytime you need to interrupt for a question, yeah, please feel free to do so. I'm happy to I'm happy to answer any questions during my presentation. I'd much rather talk with you than talk at you, which is easier to do in person than on Zoom, but still, I'm glad to answer any questions.
Dominic, what is a quorum?
10.
Okay, looks like we've got it. 23 have voted.
Oh yeah, yeah. It looks like it. We'll keep it open for the 5 minutes. I think I allowed for a bit too much time because I'm just used to having to like tabulate the paper ballots. But because so 15 minutes is a bit, you know, it's probably a little bit much, but just to be safe, you know, we allowed for 15 minutes. And I don't want to start early in case anybody gets here at 2. I wish I knew some jokes.
University of Tennessee football. If there's another volunteer out there, I'm sorry, I feel your pain.
Don't make me comment on that, Judge Woodard.
I heard that, Judge Brown.
I know you did.
You're disqualified.
That's what I figured. Listen, can I vote twice? My ballot popped up 2 times.
Oh, boy.
I think that's frowned upon.
Oh, darn.
Have you gone through the Secretary of State's office on this, Judge Brown?
Everybody else did.
You can only vote against me 1 time.
Oh, I would never do that.
Well,
Barbara, if it popped up a second time, probably it didn't register your vote the first.
Oh, great. Now what do I do? I hit submit. Well, I don't know what to do now. Can you send me another one or what am I supposed to do? I don't know.
So Judge Brown, at the bottom of your screen, you should see something that says polls. Do you see that?
Yeah.
Okay, if you click on that, I think it should pop up.
Yeah. Oh, thank you. Good.
You're welcome.
Okay. So I think that is the 5 minutes. So so Lane, if you want to end it, or I can. I see the button to end polling. Oh, there we go. All right. Well, thank you all for voting. And let's see, we still have 5 minutes. I think I could just take this opportunity to say, if anybody, this is the first presentation we've done in a while. Like, obviously, we were limited by the current situation. We would have, unfortunately, we won't get to do the section Christmas party this year. And we didn't get to have another presentation this year. But if anybody has any ideas, please feel free to email me at any time, or just give me a call. That's fine too. Our contact information is on the bar website. My email address is dcaprero@osa.ga.gov, and I'm happy to hear any ideas for presentations. Because frankly, I like doing these. And if you want to speak, or if you have an idea for a speaker, we're certainly open to ideas.
well, that's great, Dominic. And I do think before we go into it, I see a lot of friends on the list of people. We have judges from OSA, practitioners in both state government and private practice. I think a lot of them know who we all are, but some of them don't. So I think we should, before you go into it, Dominic, I think you should just lead us in giving us a brief introduction of all 3 of us, and kind of talking about where we came from and what we're doing and why we're here talking about this stuff. And then once you're ready to start, I think you should lead us off.
Sure. Yeah. Well, I guess I'll go first. I'm Dominic Ferrero. I'm section chair. I am the Deputy General Counsel at the Office of State Administrative Hearings. I've been with OSA since 2013. So since I graduated from law school, graduated law school, Georgia State University. And before that, I was at Kennesaw State University. Let's see. That's about all there is that's interesting about me, if you can call that interesting. But yeah, Alan, if you'd like to go next, or
Yeah, absolutely. Thank you, Dominic, and
sure.
thank you for your leadership in this section. Definitely am missing that Christmas party, which I think was worth the price of joining the section a couple of times over, is one of the more fun things to do. I'm Alan Lightcap. I am now a private practitioner who does a general trial practice, but a lot of my practice involves state licensing and representing teachers, in fact. And so I'm one of the people who I can say my first hearing was at OSAH back in 2012 when I was working as a law assistant for the Attorney General's office. I started my career at the Attorney General's office after graduating Emory Law School back in 2012. And so I practiced under the Third Year Act. And my first judge was that I appeared before was Judge Lois Oakley. And I've found that practicing at OSAH has been a big part of my practice, and it's been fantastic. A place where I've won some and lost some, but I've always found incredibly thoughtful decisions and definitely enjoy practicing. So now, as I said, I used to be at the Attorney General's office. I left the Attorney General's office in late 2015, and I see some of my former colleagues on the list of people that are on this call or on this Zoom meeting. And just I feel for those of you that are in the election section. I'll tell you, I'm sure that there's a number of sleepless nights and incredibly long hours, but I thank you. I know what it's like to be a public servant, and I thank you very much for your public service. So with that, I'm going to pass it to our friend, Judge Woodard.
All right, good afternoon, everybody. I'm Patrick Woodard, and can you see me okay? I've been an OSAH judge since we started, July 1995. And during that time, I've been to about every county in Georgia. I think I'm missing 3 or 4. Currently, I'm the ALJ for 4 circuits in North and Northwest Georgia. My biggest circuit is Cobb County. So more likely than not that if you run into me, it's going to be either in Canton or my cases in Cherokee County, or my cases out of Marietta. I used to be a bankruptcy litigator for years up in Chattanooga, and moved to Atlanta in the, when was it, very late 80s, and worked at the old DHR hearing office, which eventually was absorbed into OSAH when it was created in 1994, and we transferred over in 1995. And since then, I've done, I don't know, I would guess probably 15, 20,000 hearings, maybe more, and have thoroughly enjoyed my time. And to echo Alan and Dominic, I wish we were having our Christmas party. That was one of the highlights of the year. And I'll be talking with y'all in a few minutes about my perspective as an ALJ on doing hearings by these alternative means, such as GoToMeeting, WebEx, and Zoom. But that's it for me for now, and turn it back over to Dominic to get us started on the review of the new OSAH rules.
Okay. Lane, do I need to click the button to share the results of the election? I see the option to do it again. Well, let me go ahead and click it.
Yeah, why not?
There we go. Those are the poll results. And I'll go ahead and click stop share. Okay. Now I have to share my screen, so let me see if I can figure out how to do that. Share screen. And it should be this right here. Click and share. Okay, can everybody see that? Should be a PowerPoint presentation, unless I did something wrong. Can you see that, Judge Woodard?
I sure can, Dominic.
Okay, if you can, I think everybody can. So, okay, I'm going to go ahead and get started. Here we go. There we go. All right, now it's working. Okay. Well, yeah, thanks again, once again, for joining us. What I'm going to do is I'm going to go into an update of our rules. We amended our rules effective July 12th of this year. And also, just because it wouldn't really make much sense without context, I'm going to try and go into a bit of a refresher. So if you happen to, I'm sure many of you know a lot about our rules, maybe more than I do. But I apologize if you've heard a lot of this before. But just to give you a little bit of background about OSAH, we are what's known as a central panel. There are many states that have central panels. And essentially what that means instead is in some states, hearing operations are conducted internally. They're conducted by the agency, the same agency that took the action at issue. Georgia is different in that there is a separate agency, the Office of State Administrative Hearings, that just is sole function is to hold hearings and hear disputes between agencies and the public, at least for the most part. We consist of 15 administrative law judges currently, including our chief judge, Michael Malahy. We have 23 support staff members. That includes myself. We have 5 staff attorneys at the time, currently, and we also have clerks and case management assistants. And I'll go a little bit into each of their roles shortly. We have statewide jurisdiction, but we only have one permanent location, and that's the one that's pictured right there, and in which I'm sitting right now. It's on Peachtree Street, and it has courtrooms. I'm sure many of you have seen them. But every other space around the state is borrowed. We borrow our courtroom space. It's generously loaned to us for calendar dates and typically courthouses, sometimes DFACS offices, and sometimes we'll conduct on-site hearings. That's the case in cases for the Department of Juvenile Justice, and sometimes in nurse aid registry cases, things of that nature. We do conduct telephone and video hearings, and that's especially true this year since the start of the pandemic. Right now, the statistic I have is 43% of hearings were set for phone or hearing since the start of the pandemic. And I think this is either April or March. But we are still holding hearings, and we're holding hearings here, in fact. We had hearings today. Everybody's socially distanced, masks are required. And there's also a screening procedure so we can conduct them as safely as possible. But hearings are continuing, and in fact, they never really stopped, even at the height of the pandemic. We hear hundreds of different case types. We hear so many that sometimes I forget what we hear, and sometimes something will cross my desk that I didn't know we heard. We've had cases involving oyster farming, and I didn't know we heard those. And then we have cases that involve animal impoundment. I didn't know we heard those, but every once in a while you'll get even I'll get surprised, and I've been here 7 years. So as I said, we amended our rules this year, but in fact the process started a couple of years ago. Judge Malahy formed a rules committee. Our rules basically hadn't undergone an overhaul for many years. We'd had a few amendments, but we basically wanted to take a comprehensive look at all of our rules. And our goals were, we wanted to update the rules to reflect the current organization of OSAH and our procedures. Basically our rules had they didn't accurately reflect how our office looked. And we, just for transparency's sake and information's sake, we wanted the public to have, to be able to understand how OSAH operated. We also wanted to accommodate some changes in the law, most notably HB 790, which was amendments to the Administrative Procedure Act. And also there were some citations to laws that had got outdated. There were some citations to the Open Records Act that I think were outdated, and citations to the law governing subpoena. that had kind of, I think the citations were out of date. And we also wanted to update our rules just to make the process a bit easier for parties to understand, to simplify the rules where we could, and kind of cosmetically make them better looking and easier to navigate. Essentially, a lot of the process was internal. There was the rules committee. It consisted of myself and Judge Kennedy, and our general counsel, Lisa Boggs, and Kevin Westray, who's one of our CMAs. And I'm really sorry if I'm leaving anybody out, but I'm drawing a blank. But yeah, it was a long process that involved a lot of research. We looked at the Civil Practice Act, the Uniform Rules for the Superior Courts, and of course we took internal comments from our judges, and it underwent significant revisions. And then finally, we went through with formal rulemaking, which involves notice and comment, notifying the Secretary of State's office, notifying the Legislative Council. And then finally, they went into effect on July 12th. If you'd like to review them, they're available on our website. And they're actually, if you ever get an email from me, there's a link to them in that email. A lot of the revisions were comprehensive. We basically, every single rule underwent some sort of revision, even if it might have been just cosmetic in nature. But we tried to split up really verbose sections into subsections where we could, eliminate extraneous language where we could. We added some section headers just because it makes it easier to navigate. It makes it like more pleasing to the eye. That's an example, Rule 13. I think I noticed examples in the workman's comp, and either the code or their rules had that, and I found it very helpful and very organized. We updated some terminology throughout. Instead of saying OSAH all the time, we refer to ourselves as a court. This didn't change anything as far as we're not an Article 6 court. We're still very much an administrative court, and we're still under the executive branch. This was just for terminology and simplicity that we call ourselves court. Other changes just throughout were time limits, just to kind of make things easier. We specify whether the time is expressed in calendar dates or business dates. So yeah, it's just that you'll notice those changes basically throughout the rules. Our rules, for those of you who haven't seen them, it's basically, there are two chapters. There's chapter 1, and that's primarily, you may not work with that as much because it's usually for internal purposes. It's, requirements for, it just basically explains the organization of OSAH. It's requirements for administrative law judges, like in the way of the oath and continuing judicial education. But we did reorganize that one as well. And primarily our purpose behind doing it was for the public, just to understand how OSAH was organized. Formerly, the rule only mentioned the chief judge, it mentioned a deputy chief judge, administrative assistant to the chief judge, and a chief clerk. And that's somewhat accurate, but it's not entirely accurate. Currently, there is no deputy chief judge. It is the chief judge. There are administrative law judges. There are special assistant administrative law judges that are appointed. There is not currently, but there was an executive assistant to the chief judge. There are clerks and there are case management assistants. And the clerk's office was mentioned before, but not case management assistants. And the distinction is that a clerk is responsible for record keeping and case initiation. So receiving and filing case initiating documents. And typically what that is the OSAH Form 1 and any attachments. The clerk will get that. And the clerk will maintain the record. And also the clerk will close out the record and also see to any transfer of records if necessary for agency review or judicial review. Case management assistants are involved with the day-to-day management of a case. They're involved with scheduling, just managing, tracking the cases, and basically they're the contact for the parties for a case. This is going into chapter 2, and this is what you're most likely to encounter. These are the actual administrative rules of procedure. So I'm not gonna cover every rule, but I will go through and I'll cover kind of the main changes we made and the important ones. Rule 2 is just the scope of the rules. It just clarifies that the rule governs anything that's before the Office of State Administrative Hearings. There's also a provision, as there was before, this isn't a change, it's that the ALJ can relax the rules as long as it doesn't prejudice the parties and it's consistent with the APA or other applicable law. It also says that the court can refer to the CPA or the uniform rules for the superior courts to address anything that's not in the rules. So naturally, if there's if there's mandatory authority that is in conflict with our rules, it trumps. Of course, we can't supersede the Georgia Code or the United States Code or the federal regulations with our rules. If there's something that applies procedurally, and in some cases it does, that's the controlling law. Rule 3, that involves commencing a case. And basically there are 2 ways to commence a case. And it used to be 1 before HB 790, but there's, the primary mode is agency referral. The hearing request first has to be submitted to the agency. And that's still the case either way, but typically the agency will refer the case to our office on what's known as an OSAH Form 1. And that just is basic information about the case. And it usually has attachments. It's maybe a hearing request, statement of matters asserted, things of that nature. Under the APA, and under a lot of the controlling laws, typically 30 days in which to refer a case. But the law can prescribe a different period of time for referring a case as well. The second avenue for commencing a case is a petition for a direct appeal. Basically, this is just an avenue for the public to take if the individual submits a hearing request and it's not timely referred to our office. And all it guarantees is that our office will review the petition and the hearing request, and the agency gets an opportunity to respond. And the issue for the judge to determine is whether the agency was obligated to refer the case. And most of the time, when the agency is given an opportunity to respond, it will respond by submitting the hearing request anyway. 9 times out of 10, it tends to be an oversight. But basically the idea, this was the amendment to 501341. The idea was just to give the public a way to get to OSAH if the agency failed to timely refer the hearing request.
Dominic, can I step in real quick?
Sure. Awesome.
Well, I just wanted to put in my perspective as somebody who has had a prosecutor's hat on, so to speak, at OSAH, and now also had a defense lawyer's hat at OSAH as well. When I was at the Attorney General's office, we would often take, for example, teacher licensing cases with the Professional Standards Commission. I came to that office when there was so many cases from the Atlanta Public Schools and other county cheating scandals to the point where there was so many cases. And we would often have a backlog of cases, and the Attorney General's office would often have the ability to wait or to send in the case to OSAH when everything was kind of hunky-dory for the case to proceed. Maybe that means that the criminal case that's underlying the administrative case has been resolved. Maybe that means when particular evidence has been gotten, and you've waited on it, and so in the first Form 1 type of referral, oftentimes the agency and the Attorney General's office would have some level of agents, or have some level of control on the time and place that a case would actually be heard. Now with OSA Form 2, the individual who is being being sanctioned, for example, by the administrative agency, has the ability to put their case on the top of the pile. And oftentimes that is I think that it is fundamentally a good change in the law, but as a practitioner who has been on both sides of that, I would just say, for those of you who are not in the Attorney General's office, not a SAG, not a agency lawyer, I would just say as a practice tip, give your opposing counsel a heads up that OSA Form 2 is happening. And I just think that's a smart thing generally. Before you do something, before you file something, pick up the telephone call, write an email and say, hey, what's going on with this case? I was thinking about using the OSA Form 2 to get an expedited hearing. And that way you can, give people a heads up of something is coming, so as to not kind of disrupt the apple cart, because there might be a reason that the case hasn't gone to a hearing. That was a long digression, Dominic, but I thought
okay.
I thought it was a nice or an important practice tip to maybe share.
Yeah, absolutely. Yeah, thank you.
Thank you.
Okay, let's see. And so, Rule 4 involved a lot of cosmetic changes, just because it was a lot of text, a lot of words in that one. So it was broken up a bit, and we added some headers, but there were also some substantive changes. The rule now provides that documents filed subsequent to case initiation are to be filed with the CMA, and that's pretty much always been the case. For the old rule said filed with the ALJ. Nothing was, typically it wasn't, unless you're in court, it wouldn't be filed with the ALJ. It's usually the communication between the OSA and the public was between the CMA and the public. But now it provides expressly that it is to be filed with the case management assistant. There's also a significant change with filing dates. The rule now expresses, depending on how you file, the filing date may be different. Document filed in person, they're considered filed the date they're received. And the only exception if it's somehow gets in the office, but it's submitted outside of office hours. Like maybe somebody happens to be here, but it's outside of office hours, or if it's slipped under the door, it would be considered filed the next day. But if it's filed within office hours, if it's filed in person, it's the date, the file date is the date received. For mail, the file date is the postmark date. And that was the case before as well. And for electronic means, it's the date that's supplied by the electronic means. So for example, if it's filed by email attachment, which is permissible under our rules, it's the date that the email gives. And that's regardless of if it's after 4:30. If it's after business hours, the file date is still the it's still the date it's actually submitted by email. A bit of a change with non-conforming filings. A judge basically has the discretion to reject a filing that doesn't conform to format requirements. Say if it's not, I don't know, it's not filed on 8.5 by 11-inch paper or something. I've never seen something rejected for that, but if it was and the judge rejected it, it used to say that the individual has 10 days in which to correct. The current rule just leaves the deadline in which to correct up to the ALJ.
And Dominic, let me just come in again.
Sure.
I've got to say that the new OSA e-portal is incredibly user-friendly and intuitive. Man, I mean, I for the longest time, I thought OSA had the easiest way of filing possibly. Like back in the day, you would just email a PDF to the judge's administrative or the case management assistant. And I've dealt, Kevin Westray, Chelsea Unshold, people, the amazingly talented and capable administrative help for the court, and very easy. And when the e-portal came out, I said to myself, well, this is going to be different now. We can't do email filing. And when I set up my username, set up my ability to use the OSAH e-portal, I was just blown away at how user friendly and intuitive it was. Like, frankly, it's better than Odyssey. It's better than Peach Court. It is just awesome. So I commend everybody who's listening. If you haven't already done it, please take the time to register with the OSAH e-portal and play around with it. There are these great little codes that come in the notice of hearing. I don't know. I think I can show this and people can see it. A lot of times, oh no, this is.
I can sort of see. Yeah, that's the one.
So there's like a little code that comes in the filings where you can plug in that code in the e-portal, and it'll take you right to your case. And it's awesome. So I've just got to say, well done with that. And, congratulations on an awesome platform.
Oh, thanks. Yeah, Lisa worked very hard on it, and it's like, I think we're very proud of ePortal, and I'm glad you reminded me, because I almost forgot. We do have electronic filing now, and it's a code on the notice of hearing. It should be on every notice of hearing now, because I did personally work on adding those to it. It should show up. I can't 100% guarantee that it will be, but it should be live for pretty much every case type.
I have a question from Kevin Bradbury on the chat. It says, in some cases, it seems as if electronic filing through the case clerk was accepted and acceptable. Do these rules change that? That's kind of asking what I was asking, like, can you still file through the case assistant even though there's an e-portal?
Oh, sure. Yeah, ePortal is completely voluntary. Yeah, if you want to file by email attachment, or if you want to file by paper, then yes, you are absolutely permitted to do that. The ePortal is merely for convenience. It's a great tool to use, but unless you get an order otherwise, and I've yet to see such an order, then all forms of filing, as long as service is proper and the proper requirements are fulfilled, you aren't required to use ePortal. It's merely, it's just a tool that's at your disposal.
Well, I've got to say it's awesome. And another great thing about it is you can see the entire docket right on your computer screen, right there, and you can download PDFs of things that are previously filed. So let's say you get hired into a case that has already had some litigation in it. Instead of calling somebody up or emailing somebody, hey, what has happened in this case? Boom, ePortal has it all right there. So I think it's really awesome for that.
Let's see. Okay, yeah, now we're at Rule 5. There actually weren't many changes here, and really these weren't changed. So there's not much of a point in going into them. The change to Rule 5 was pretty much cosmetic, with the exception that Rule 6 was merged into it. It used to be that Rule 6 provided that the court could change the time periods expressed in Rule 5, but we just felt that, it still has to do with computing time. So we just kind of merged the rules together. Essentially, what Rule 5 provides is that it specifies what a time period, what a time period means. It's let's see. So if it specifies that any time period begins the first day following the day of the act that initiates the time period. So that just means, say, if a party is served on December 9th, then day one of the response is due 12/10. That wasn't a change. That's always been in Rule 5. Also, it specifies that if the last day of a time period is on a day in which it's basically not on a business day or it's on a state holiday, a day on which the court is closed, then the period extends until the termination or until the termination of the next business day, like when the court reopens. And there's also this is not a change, but if a party is served by first-class mail, then 3 business days are added to the response period. But that's all in Rule 5. That's been in Rule 5. It wasn't changed. I think it was all the changes to Rule 5 were cosmetic. The burden of proof, again, most of the changes to this one were just, it was just reorganized. It was split into subsections. The default rule, not to be confused with an actual default, but it's typically the agency will bear the burden of proof, and then it lists several broad exceptions. And these are basically principles of due process. In a case involving termination of benefits, the termination of existing benefits, the agency will bear the burden. And if it's a case like a denial of application, the applicant will bear the burden. That's all the same. Nothing changed with respect to Rule 7, with the exception that we did clarify that affirmative defenses, and I think these were mentioned, but it wasn't as clear. If you make an affirmative defense, then the party raising the defense bears the burden. As before, the court can alter the burden of proof, but as long as it's prior to the commencement of the hearing. And it also, this was in addition, it just clarifies that changing the order of proof does not alter the burden of proof. And the reason this is important is because the order of proof is often changed. And this is very important for many of our public assistance cases in which the petitioner is pro se. It's just very ill-advised to start, even if the petitioner bears the burden of proof, it's just kind of burdensome to allow them to go first, because the party with the most information who can better explain, who can provide a sort of narrative, is the agency. The agency will have more information. So typically the judge will change the order of proof. And this just clarifies that that doesn't have any effect on the burden. Rule 14, it's just basically what the change to this rule, it's often the case that there will be pre-hearing conferences and there will also be pre-hearing orders. And orders will often call for exchange of exhibits and exchange of identification of witnesses, exchange of witness lists. And this just created just express authority for it. It's now written down in Rule 14. And this rule clarifies that there's no right of discovery in OSAH cases, and that's just always been the case. But in creating this procedure, or at least explaining this procedure, we wanted to make it clear that it's not discovery, it's not a discovery procedure, it's just merely a judge's order saying that, like, hey, and this rule is this change is especially important with the continued proliferation of video hearings and telephone hearings. Oftentimes, the only way to do it is to have people exchange exhibits in advance, because it's just very, very cumbersome to not have seen an exhibit before the commencement of a hearing, a video hearing or a phone hearing. There's no way to exchange it in person. You don't have that nice pre-hearing time that before the hearing gets started at the location. So it was a good addition. Rule 15 it actually involved a lot of substantive changes. This is the rule governing summary determination. For those of you who are not familiar with summary determination, that is our equivalent of summary judgment. There are just now, I may not get to every one of them, but now there are actually more specific requirements for the motion. The motion has to contain concise and numbered statements of material facts. Each fact has to include citations to evidence. And naturally, the judge could relax this rule under Rule 2. However, basically what this rule is designed to address is a lot of the times what we'll see is just a long-winded argument that doesn't include actual statements of material of fact, doesn't include exhibits or citations to evidence. It's basically just a brief or an argument that is styled as a motion for summary determination. And this is just designed to address that situation. Another of the big changes to this rule is even if there's a completely adequate motion for summary determination, it's got concise and numbered statements, it's got citations to evidence, the judge can still conclude that the matter should proceed to an evidentiary hearing. Like under ordinary circumstances, maybe yes, the party would be granted granted summary determination, but the judge will still say, no, this should go forward with an evidentiary hearing. The reason for this requirement or this rule change was just for the sake of pro se parties. Like, and if a pro se party, they may not know about summary determination. They may not be able to adequately respond to summary determination. So it's basically allowing them to go forward with their evidentiary hearing anyway. But before, I would encourage everybody, if you were planning to file a motion for summary determination, I would encourage you to look at Rule 15 because there were some significant changes to it. Rule 16, it governs motions just in general. The time limits are the same. It's just expressed in calendar days now. It just specifies that they have to be filed at least 10 calendar days prior to the hearing date, and the response is due 10 calendar days after the service of the motion. Sorry, I just wanted to check how I'm doing on time. Okay. One change, but it's to the motion time limits, but it's actually expressed in Rule 41, is that the judge now has the ability to grant motions for continuance if they're filed, even if they're filed within the 10-day time frame, as long as the opposing party has been served and the movement has shown good cause. And the reason for this requirement is there's very quick turnaround time in ALS cases. And often good cause for continuance will arise. It just arises suddenly. Those cases involve law enforcement, and sometimes there's perfectly good cause for continuance. It just, there wasn't enough time to make an adequate motion within before the 10-day time frame. There were some changes to rules of evidence. Much of this involved, substantively it's the same, but a lot of this involved just removing extraneous information. For those of you who don't know, our rules, we just cite to the evidence code that's in the APA. We apply the rules that are applied in civil bench trials. So chances are if there's an evidentiary question, it's addressed by Title 24. The exception is that, and this I think is applied very sparingly, but facts that are not reasonably susceptible of proof under the rules of evidence can be used if they're of a type relied upon by reasonably prudent persons in the conduct of their affairs, or they consist of reports of medical, psychiatric, psychological evaluations routinely submitted and relied upon an agency in the normal course of its business. And it clarifies that if you just don't call a witness, that even though the witness was available, then that doesn't mean it's not reasonably susceptible of proof. That just means you failed to call a witness that you could have called. The rule, it used to have a very long-winded list of the types of evidence you could admit, like plats and maps, et cetera. When we were in the Rules Committee, it just seemed extraneous. There's no real need to identify. If it's admissible under the rules of evidence in a civil bench trial, then it should be admissible in our proceedings. And so we just didn't feel the need to express it. Rule 19 was basically reorganized. There weren't many substantive changes to it. I'm sure you're all aware of what subpoenas and notices to produce are. One clarification is that in our proceedings, a subpoena or notice to produce, it doesn't guarantee access to a document in advance of the hearing. It's not a discovery mechanism in our proceedings. It merely guarantees the production, the attendance of a witness or production of a document at the hearing. But most of the rule remains substantively unchanged. Rule 28 actually did have a significant change. This is for motions for reconsideration or rehearing. Formerly, there used to be no standards for reconsideration in our proceedings. We would just look to, essentially, we would look to other case law or in the code for a standard. But now the rule actually expresses standards. The court has to consider discovery of new evidence, intervening development or change in the controlling law, or the need to correct a clear error or prevent a manifest injustice. I can't remember precisely where we pulled that language from, but I'm sure that's expressed elsewhere, whether it's in the code or if it was in case law or the uniform rules. But I'm certain that that language is from another source. It's distinguishable from a motion to vacate a default. The standards are different. A motion to vacate a default, the standard is providential cause or excusable neglect. Essentially, it was whoever was defaulted, it's, they were at fault. It wasn't the court's fault, but there's a reason for it. There's a providential cause or excusable neglect, and that standard remains unchanged. There were some changes to the requirement for attorneys. In general, parties, if they are represented, whomever is representing them must be an attorney in OSAH cases. And the exception, and the big exception, is public assistance cases. And that's a Code of Federal Regulations requirement. So in Medicaid cases and in food stamp cases. Interestingly enough, and this is fairly recent, and by fairly recent, I mean the past few years, at least that we've noticed, in Medicaid cases, there have actually been business organizations that are answering for petitioners in Medicaid cases, and that's permitted by the CFR. But yeah, in public assistance cases, individuals need not be represented by an attorney. They may select a non-attorney representative. We did add express requirements for entries of appearance. And these were actually pulled from the uniform rules for Superior Court. But there's just basically, if you file an entry of appearance, there's express requirements for it. And naturally, these can be relaxed by the judge. But it's basically the style of the case, phone number, email, things of that nature. We do have, there is an allowance, as there was before, there's an allowance for resident attorneys. And unlike in other courts, officers of business organizations such as corporations can represent a corporation in OSAH proceedings. And the rule specifies, I'm not sure if it did before, but it does now, that OSAH cannot appoint counsel. I'm not aware of any provision that allows us to appoint counsel. The rule 41, it now distinguishes between notices of conflict and motions for continuance. And now it specifies that one can't be embedded in another. The motion for continuance has to be filed separately. But note that the judge can relax requirements. In some instances, a judge may accept a motion for continuance that's embedded in a notice of conflict. And I think this is the final change, and I'm probably running up on my time, so it's pretty good. Rule 43, it used to be that it had all the requirements were expressed in the OSAH rules. We actually elected in the rules committee, we elected to just cite to the uniform rules for the Superior Court. In general, throughout the rules, what we tried to avoid was citing to another authority. Just what we wanted to do was express every requirement in one place so that a party, especially if they're pro se, they don't have to go hunting around for another law or another rule. Everything is just right there. But we made a couple of exceptions, and one was Rule 43. And the reason we did that is, for one thing, it's now the rule, if the uniform rules for the Superior Courts are changed, our rules will change along with it because we cite to their rules. Another reason is because typically media requests are not made by pro se parties. Typically they're made by news organizations. They have their own legal counsel. In fact, they're probably much more familiar with the uniform rule for the Superior Courts than they are with our rules. So it makes sense that we would just cite to the uniform rules. But this is one of the rare exceptions we made to citing to other authority as opposed to just expressing all the requirements in our rules. And I think that is basically all I have. That's not every change that we made. I tried to hit the basically hit the main points. But if you'd like to review our rules, you're of course welcome to. They're up on Lexis, they're up on our site, and they're up on the Secretary of State's website as well. And so with that, I'm gonna go ahead and turn it over to Alan. Did you want to go first, or?
That's up to Judge Woodard. I really just had some bullet points to share that I could just go real quickly on, and I think that this August group of practitioners and judges would like to hear from Judge Woodard, because they haven't heard from him as much, and I feel like I've talked a little bit. But Judge, we're here to talk about remote hearings, and right now we're on Zoom, but I know OSAH uses GoToMeetings, so perhaps that's a good segue to go into some what you want to say.
Sure. And I've been asked several times why we don't use Zoom, why we don't use WebEx or one of the other applications. And from what I understand, it's because our telephone provider, that's what we use. So GoToMeeting is pretty powerful. It doesn't have the same functions as WebEx. It may have a few more than Zoom. I'm honestly not as familiar with using Zoom. Usually it's when we're doing these CLEs, that's when I deal with that application. But one of the things that I have found, and I'm just going to go through some bullet points myself for some problems that I've run into in doing these hearings. First off, if you're doing an audio only hearing through GoToMeeting, no video, if you have a landline available, I would recommend that instead of using a cell phone. Now, the judges have access to this through a URL, through their laptops or their personal desktop computers. I have found some problems with that. And I've actually, in the last week or so, had to stop a computer hearing where I was the person running it and call in using my cell phone. So if I'd had a landline available at my house, I would have used the landline. I find it to be stouter, much more functional. Now, let's say that you have a telephone hearing and you've got a pretty complicated case. You really want the judge to see your witnesses, be more involved that way with visual. Nothing prevents you from filing a motion for a video hearing, and you certainly can do that using OSAH Rule 15 for motions and OSAH Rule 22, and let's get the exact section, is the one that provides for alternative hearings. How about 22.4? A hearing or a portion thereof may be conducted by an alternate means if the record reflects that all parties have consented and the alternate means will not jeopardize the rights of a party. During the COVID epidemic, at the very beginning, we did have some parties who objected to not having an in-person hearing. We did pre-hearing conferences. I didn't twist anybody's arm, frankly, but they did agree that it was best to go ahead and do a GoToMeeting video hearing, and it worked out pretty well. I think people have been generally pleased. Let's see.
I agree, and you know, a lot of times, Judge, I think the best thing here is to just kind of have a conversation about it, and let me just pop in and in the hearings that I've done at OSAH, we've agreed to a teleconference hearing or to video hearing, but also the courtroom was still open. And so essentially it was kind of a mixed hearing where I decided with my client, and frankly, the other side with their assistant attorney general decided to actually come to OSAH, and everything was very conscientious of health and safety. But we went into the courtrooms and then just had witnesses appear via teleconference, telezoom, or the GoToMeeting application. And, OSA has these big, beautiful TVs that nobody used to use as much, and now we can use those. And so I think the point is that there is some flexibility. It doesn't necessarily have to all be on telephone or all be on video, and it doesn't have to all be in person either.
Absolutely. What I've done lately is I brought Cobb County administrative license suspension cases here to OSA. It basically was because we didn't have any available courtroom space in Marietta. So they had to come here. We're only about 15 miles or so from downtown square of Marietta. It's pretty convenient for the parties, and the show up rate has been quite high. But I've agreed to grant motions for many attorneys, many officers to appear remotely. They had usually very good reasons. They had either been tested or were concerned about being COVID positive, or they had some underlying medical issues and were, of course, hesitant to make the trip to Atlanta. So we granted them. Now, what happens in those cases is really very simple. I will call the calendar here at OSA and immediately call in to the phone number for the GoToMeeting app. And the attorneys or the officers or other parties will just simply check in as we go along. And it's worked extremely well. Now, can y'all still see me? My screen just changed kind of unexpectedly.
Yeah, it's just
stop sharing.
Okay. One thing that's happened that's been kind of interesting is on the GoToMeeting app, as I said, sometimes things don't go perfectly. And I had one case where it was pretty obvious that the attorney on the video was trying to object, and he was doing everything but jump up and down, and you kind of tell he was trying to get his point across. So we came up with, I think, a pretty common sense way of doing it.
I love it.
Now, it turned out that he was a little agitated, might be going to the extreme there. He was just concerned that I was not understanding that he was wanting to object. It turned out that he'd accidentally hit his mute button. But anyway, during the rest of the hearing, we did this. Things went extremely well. The witnesses were immediately coached to stop talking when they saw a card come up like this. It went really well. Anything to add into that, Alan?
I think that's exactly right. And I think that is a good thing to do for the lawyers and practitioners beforehand, to just say, hey, this is because of this brave new world we're doing with video conferencing. Everyone has to be so much more cognizant of talking over one another. You know how oftentimes when you're sitting in a deposition, in the little spiel speech that the deposing lawyer will sometimes say is, make sure to let me finish what I'm saying before you respond, so that we don't have over talking. I mean, that is something that is important for any situation where a record is important. But I would say with the technological issues that we're having with video hearings, it's amplified and even more important to make sure that you allow people to finish their thoughts. And then also, what to your point, Judge, with regard to objections, have the witness immediately stop and tell them beforehand to take your prompts from the judge.
One other thing that's come up, and as I said, I do a significant portion of my hearings here at OSA. Also, I've got 3 remote courthouses in Cherokee, Bartow, and Gilmer counties that I use, and they've been very wide open to us having in-person administrative hearings. We have some of our judges, I think Judge Teet's the one that comes to mind especially, who have done significant dockets, probably more telephone hearings than I would be comfortable with. I think that goes to unfortunately, I'm not the best with computers. I'm not the greatest with electronics, frankly. My staff attorney is on this call or on the meeting right now. Brian, could you spend a minute or two talking about how Judge Teat handles his large ALS dockets and other dockets down in the southern part of the state?
Sure, Judge Woodard. And can you hear me? I was actually having some internet difficulties, so I am on the phone.
Yes,
Yeah.
we can hear you just fine, Brian. And Brian is not only my staff attorney, but he's Judge Stephen W. Teat's. Those of you might know Judge Teat. A lot of his career, he's been down on the southern coastal area of Georgia. Go ahead, Brian. How does Judge Teat do these massive dockets of his?
Thanks, Judge. I will say, Judge Teat, this is all his method, and I kind of just assist him the best that I can. We use GoToMeeting, and most parties are joining by audio, so they're just phone only and not video. So we arrived to the meeting earlier through the web application on GoToMeeting, and the best part of it is that each caller will have a little number. So it'll say caller 1, caller 2, caller 3, on and on for as large as our docket is. And then it will also notify you when a particular person is speaking. So for example, it would say caller 18 is talking. And what I do is I try, as soon as I see someone has joined, I will ask them to identify themselves, and I will go in and manually edit the caller 18, for example, and then change it to the person's name. And because logistically you may not be able to hear someone clearly, I'm also cross-referencing at the same time the docket to see who the person's name is, what their attorney is, if they have an attorney. And another key part of this, which I think Alan brought up, was that there are times when you naturally have multiple people talking at once, or you get a lot of feedback and background noise, which can be disruptive, especially on a large docket. So after I check people in, I generally mute everyone until the calendar call, just to be clear and have no interruptions. But GoToMeeting also, because it will show someone is talking, for example, like I said before, caller 18 is talking. It will also do that based on the background noise or feedback. So through that, assuming I hadn't muted everyone, it allows me to see who is having feedback issues and interference issues, and either I will mute them myself, or I can speak to them directly and ask them if they can hang up and call back in, or perhaps try a landline or a different phone or a different method of joining the call. Thankfully, the reason we're really able to do such large calendars is because many of the cases, at least for ALS administrative license suspensions hearings, we are doing so with a lot of attorneys and a lot of represented parties. We do get a certain amount of pro se petitioners. So for those calendars, I will actually speak to a group of pro se petitioners in a second GoToMeeting. So we break off from the larger meeting to a smaller meeting, and I will try and just walk them through the process, what their options are, what it means. We aren't actually allowed to give legal advice, as you know, so I'm kind of limited in what I can say, but I try to give them some broad strokes and overarching information so that they can make an educated decision about how to move forward, whether they want a hearing, and what their options are. But GoToMeeting has really been great for us. I don't know how it compares to Zoom and other in terms of functionality, but I assume there are similar processes at play.
Awesome.
Thank you.
Okay, thank you, Brian. One other thing that's pretty significant that I've found during these hearings is, we do public assistance cases, and that can be anything from a few dollars a month in food stamps to a pretty significant, say, resource disqualification for someone in a nursing home. And bottom line is all cases are not created equal. And if you're representing a client, either a client agency or a client claimant in a Medicaid case, and you find that you got your case put in there with 40 other cases on a morning for telephone hearing, and your case might take a couple of hours, let us know. Again, using OSAH Rule 15, motion practice, file a motion for a specially set hearing. You might also want to file it at the same time to special set it for a particular day where you can get your couple of hours of trial time. Also, maybe do it as a video so we can see your witnesses. I got completely surprised a couple of weeks ago when I pulled up my calendar the morning of a hearing, and there was a case that I knew could take me 8 to 10 hours to hear. So we had to do some pretty fancy footwork and get things moved around. But attorneys, especially those with agencies, let us know ahead of time if it looks like your case is going to involve a whole lot of issues. I may not know that an attorney has filed an entry. So just let me know. We'll be flexible with y'all and give it the time and the resources it needs. Alan, anything you can think of on that?
No, I think that's exactly right. I do want to, is this a good place where I can kind of go through my little tips and tricks and just kind of, or at least a good stopping point for you, Judge, or do you have a couple other bullet points to hit?
Maybe one or two, but I can get them in later.
Well, why don't you just, why don't you just keep going and I'll just close this out.
All right. I was kind of looking forward to listening to you.
No, well, then, you know what? Hand the football off. I'm going.
Yeah, I'm going. Remember, I'm a Tennessee grad and we don't play football. So we're a basketball school. I'll make a good pass. All right.
Well, okay, so I'm going to share my screen. And here are my video hearing tips and tricks. First things first, you'll see I took off a Zoom hearing and the Sacramento Superior Court. That's my little picture on the right. But the thing I think is be aware of your surroundings. I have now done a bunch of these Zoom hearings or these video hearings, and I have now made all the mistakes that I'm now telling you not to make as the supposed expert. One of them was today. I was in what is called a notice of charges hearing in magistrate court, and my my internet, which had never been a problem before, just the Zoom kept on popping up and saying your internet is unstable. And I said, oh, well, great. Thank you, AT&T. And so for today, you can see my guitar and my bookcase. I am now in my living room where my internet router has it lives for its life. And I've actually Etherneted into the internet because I was not going to have this again. And frankly, I think we are so spoiled by having good internet that we just don't even think about that. But frankly, Wi-Fi can go out, and there's nothing worse when you're trying to confront a witness or make a persuasive argument with the judge when you say to yourself, ah, man, I just really made a great point. And then the judge or the witness says, I didn't hear any of that. And so I'm now hardlined into the internet, and there should be no reason that you guys cannot hear everything I say. My other bullet point here is speak clearly and wait to be heard. Sometimes use hand cues. Judge Woodard already handled that. That is very good advice. Oftentimes when you object, you'll have to, I think maybe it's just a matter of like, we have to relearn politeness and relearn the kind of rules that we learned in elementary school, which is wait to be prompted to speak and don't talk over other people and stuff like that. And of course, under the first bullet point as well, there's the just be aware that you're on Zoom. Like nobody wants to have a Jeffrey Tubin incident or something much different than that. I think everybody knows what that is, but like, it can be, we're not used to being put onto video and to have everything that you do be broadcast, but it is something that is just important to be mindful of, and like, just be aware. My next is when objecting, wait to have the judge prompt further. Practice with this technology in advance. That's a big thing. Like if, even if you're not the most Zoom or GoToMeeting technologically literate, you can take the time to learn how to unmute and mute yourself quickly. And frankly, that's what I do. I have a hot hand when it comes to mute and unmute. Usually I keep myself on a default as muted, and then I listen, and when I need to unmute, I can boom, boom. I was doing it quick, and then my computer just did something really weird right there. But anyways, I can unmute and mute very quickly, and it's something that I've practiced. So as it pertains to witnesses, if possible, one thing that I've done, if it's going to be a completely video hearing, I've seen this done where you have your witnesses come to your office, because technology is not distributed among our society completely equally, and some people don't have several computers or good data plans on their phones. And so one way to fix it, to ensure that there's not going to be any technological snafus with regard to your witnesses, just bring them to your office, maintain social distance, but that way you can be like, I've got this. Like, we're not going to have a Wi-Fi problem. We're not going to have a data plan problem. You'll just come here. And that can sometimes create some issues with the rule of sequestration of witnesses, but we're all lawyers. We're all do things with the honor system all the time. And I think that the thing to do is to address it with the court and address it with your parties and be like, yes, we're not going to have, like, if you have 3 witnesses that you're going to testify and they all came to your office, just address it at the beginning and make sure that the witnesses don't hear the other witnesses testify. Now, this is something that OSAH already does, and that's the exchange of documents in advance. And whoops. There's a pretrial order in all of my OSAH cases that usually mandates that documents are exchanged between the parties and also emailed to the case assistant before 2 days before the hearing. And that is not only good practice just generally in your law practice, but it's also it helps with the logistics of getting these documents in a place where they can be utilized. With regards to how to do that, I'm going to see if I can show you guys real quick. So I'm going to, let me see here. So I'm not sharing the screen anymore. And let's say that I was examining a witness. One way to do that so that the witness can see it on the Zoom hearing is to share your screen. And you can see right here, what I have now shared is just the ballot for the election that just happened. It could have been anything, but that's just what I decided. And you can, I believe I can, if let's say this is an important part of any document, you can zoom into it and be like, read this, who was on the ballot for Public Service Commissioner, Jason Shaw, Robert Bryant, Elizabeth Milton, all that, blah, blah, blah. So like I guess the thing there is that sharing screen can be a way to identify particular parts of documents so that you know that your what you're zeroing in on is seen by the judge and the witness. Again, I said mute judiciously and learn how to quickly mute and unmute. That you see that every time you're doing one of these. Somebody who is not aware that they're muted, and that's just like typical computer skills. Now we are getting a professionalism credit in this, and I wanted to just talk about professionalism a little bit. About everybody is so stressed out and has had their lives completely upended by this pandemic, that I just think that professionalism is even more important now. And it's with regard to having to do video hearings, I think it's just incredibly important. I think that politeness goes a long way. Don't talk over people. I think that because of the challenges of having to do online hearings, typical kinds of evidentiary disputes are even more time wasting and fruitless, that like we should just stipulate to documents. Like maybe you don't want to, maybe you have a long shot objection that you might have made in court for any number of technical reasons, but when it comes to having to actually proceed with a real on the merits hearing, you're wasting a lot of time when you're fighting over evidentiary matters that could have been stipulated to. And also, because the pandemic is happening, I think that you should just give more leeway to your opposing counsel than maybe you would have if it weren't the time of COVID. And that would be to consent to continuances, and like to don't just be disagreeable to be disagreeable. Like I had one client who in a different court, but one of the witnesses wasn't able to or asked to have it to be excused from coming to court that day because one of their family members was in the hospital with COVID. And my client was like, well, isn't that good for us? That's one of the big witnesses who is against us. And I told them, I was like, listen, there's no way that the judge is not going to grant this continuance when someone's family member is in hospital for COVID. So not only is our insistence on proceeding despite this witness's unavailability not going to fly, the judge is not going to rule the way you want it to, but the judge is also going to think you're a jerk. I mean, let's just get real. Like a lot of these cases come down to credibility of witnesses and, who they think might have done things, or like a lot of these amorphous things about who to believe in these disputed issues of fact. And if one of the things that you show to yourself to be is uncaring and trying to seek every advantage, trying to get every advantage in a kind of bad faith way, that's going to bleed over. Even if it's not going to end just at the particular battle that you're fighting right then. It'll bleed over to the merits, and frankly, it's just something that we as lawyers need to rein in our clients on. And so those are just kind of my thoughts. That's all I have. I was really just wanting to do kind of bullet points on this. Does anybody have any questions? Let me check the chat real quick. It doesn't look like it. I'm very thankful for all of y'all's attention. It's now 3:08. We said we were going to go to 3:15, but I see so many friends and colleagues and members of the judiciary in here. I just thank you for your attention. I hope that I have been somewhat illuminating in my perspective as a practitioner who has to be a small firm lawyer in the time of video hearings and the time of COVID. And I thank you for your attention. I hope it was worthwhile. And I'm going to pass it on for Judge Woodard for, hey, Rebecca, I just saw your video. Rebecca, by the way, was my supervising attorney for my very first hearing at the Attorney General's office. She's now at the Office of Bar Admission, but she was at the AG's office along with me. And, you know, it's been a fun ride at OSAH. So, Judge, please take us home.
And I do see that we have a question from Rebecca. The question is, does OSAH have plans to keep the option open for video hearings in the future once the pandemic is over? And I don't speak for everybody, but I think the answer is absolutely yes. I think we had the capability of doing video hearings before, but they were a bit more cumbersome and people were a bit less familiar with them. But now that they are, I mean, I think it is certainly an option. I see absolutely no reason why video hearings shouldn't be an option. And with the caveat that there is the requirement, and it still has to adhere with the APA and our rules, but the option will still be available. It'll still be there. I see no reason why it would stop.
I could throw my 2 cents worth in. I'm not planning on scheduling any public assistance hearings in person unless a party moves for it going forward. And I don't know if my attitude on this will change at the end of 2021, but I don't know. At this point, I just can't see going back to in person. It's just too convenient for all the parties. And as we go along, our procedures are getting more efficient. I think it's working really well. So that's my 2 cents worth. My answer would be, yes, we're going to continue to do video and audio hearings for the foreseeable future. One thing, and this is just kind of silly, but I had a video hearing one time, and red lights on these hearings are bad. If you see a red light and you're trying to participate in a hearing, it probably means that you're not. Either your video is off or your audio is off. So please be mindful. Red light's bad, unless you want them to be off. But if you're the attorney representing a party, you might want to keep it on full time. I can't think of anything else I need to add. Alan, Dominic, anything else y'all can think of?
I will say that it's having an in-person hearing. I think at OSAH, a lot of people prefer to have an in-person hearing. There are certain conveniences to having a hearing in person. I mean, you have the documents right there. You have the parties right there. You don't have internet connection issues. There are certain advantages to video hearings, though. I mean, there's clarity for one thing of the audio, and there's the ability to. I mean, sometimes you could make use of the chat even, and there's automatic chat logs, which is nice. So it's kind of, I'm glad. I think we will continue to hold in-person hearings. We have held in-person hearings. We will continue to hold them. But to have the option of using a video hearing, I think we were also very fortunate in that before the pandemic started, we were transitioning over to our new phone system, our new web-based phone platform that allowed us to use GoToMeeting and allow us. So we were fully prepared once the pandemic, and that was just pure. That was just pure good luck. And it was, so once it hit, we were pretty much ready to go with video hearings. And some, I just think it's a great option to have. I'm a fan of in-person hearings, but I'm glad that we have the option of using video hearings.
And just so I'm not misunderstood, the only case type then that I'm talking about continuing to do by video and audio hearings is public assistance cases. Child support establishment and ALS cases, BUI cases, DNR, DOE, almost any other case type out there. I'm still planning on doing as many of those as possible as in-person hearings. So just wanted to clarify.
Okay, well, I think we're at our time. I don't want to take up any more of y'all's time. So let's take one last opportunity. If anybody has any questions, and if not, we will just, I think we'll just call it a day. And thank you again very much. And I'd like to thank my co-presenters. It was very interesting. I had a great time, and I hope we can do it again. If not in person, then we'll do another, maybe another video presentation.
Right. And I believe, so y'all know, I think that the section paid for the CLE dues. Is that right?
Yeah, that's correct. This is, yeah, this is being offered free. There's no cost for attendance.
Yeah, so we're very thankful that you guys came. We're glad that we can help you whittle down your CLE balance. And if anybody's like me, there's still some ways to go. I think I still have 6 hours to go. So let's get those in before I believe March of next year, I think is the deadline. So thank you all so much.
Thank you, guys.
Well, have a good day.
Thank
Take care,
you.
everybody. Be safe.
Thank you.